When you buy a house, you assume you own everything that comes with it. The yard, the trees, the ground you stand on. But across a huge part of this country, you might not own what is underneath it. The rights to the oil, the gas, and minerals below your property can belong to a complete stranger. And in many states, that stranger has the legal right to come onto your land and drill for them. Here is the part almost no one explains. In the United States, a single property can be legally split into two separate estates. There is the surface estate, your house, your lawn, everything you can see. And there is the mineral estate, the oil, the gas, the coal, everything below the ground. These two can be owned by completely different people. And once they are split apart, the law calls those mineral rights severed. And here is why that should stop you cold. In most states, the mineral estate is dominant. That means whoever owns the minerals under your house has the legal right to use as much of your surface as they reasonably need to reach them. A drilling pad in your field. An access road across your yard. A pipeline. And in many cases, you cannot legally stop them. You just own the dirt on top. So before you fall in love with a property, you need to know what is really happening beneath it. That is exactly why I built buyerBeaware.io. You put in any address, and it pulls the public record, including nearby oil and gas wells and drilling activity, in about a minute. Finding out there are active or orphaned wells next door is the kind of thing that should change your offer, or at least send you asking much harder questions. The link is in the description. So how do you actually find out if the mineral rights under a house have been severed? You look in two places. First, the deed. A severed mineral estate often shows up as a mineral reservation, where a past owner sold the house but quietly kept the minerals. Second, the title commitment, and specifically the Schedule B exceptions. That is where a recorded oil and gas lease, or a severed mineral interest, gets listed. If you see it there, the seller probably cannot give you what is underneath, because they do not own it. And this is not some rare, fringe problem. It is extremely common across a wide belt of the country. Texas, Oklahoma, Colorado, North Dakota, New Mexico, Pennsylvania, West Virginia. These are split estate states, where severed minerals and active drilling are just a normal part of buying property. If you are buying in oil, gas, or coal country, you should assume the mineral rights may be severed, until the title work proves otherwise. Now, it is not completely hopeless. A growing number of states apply something called the accommodation doctrine, which requires the mineral owner to work around your existing surface use where they reasonably can. And you can often negotiate a surface use agreement that limits where and how they operate. But these are protections you have to know to ask for. The default, in most of these states, still favors the person who owns what is below. There is one more thing to check that catches people completely off guard: existing wells. An old, idle, or orphaned well near or on the property is not just an eyesore. It can be a real liability. For leaks, for the cost of plugging it, and for the questions your lender and your insurer are going to ask. Look up the well's status and its plugging records with the state oil and gas regulator before you commit. An unplugged well can quietly become your problem. So here is your checklist. 1. In oil, gas, or coal states, assume the mineral rights may be severed. 2. Read the deed for a mineral reservation and the title report's Schedule B exceptions. 3. Ask the seller, in writing, what they actually own and will convey to you. 4. Check the state regulator for nearby wells and their plugging status. And 5. If the minerals are severed, negotiate a surface use agreement or a waiver. You can buy a house, pay for it in full, and still not own the ground beneath it. It is one of the strangest quirks in all of American property law. And it is sitting right there in the title work, waiting for you to be the one person who actually reads it. So before you sign, read it.